Riley Sprinkle.
And I'm Lexi Warhay.
And we will be presenting on the Davis v. Monroe County Board of Education case. The question that arose from this case was, can a school board be held responsible for student-on-student harassment under Title IX of the Education Amendments of 1972, which are meant to secure equal access of students to education benefits and opportunities?
This takes place in a 5th grade elementary classroom in Monroe County School of Forsyth, Georgia. The Monroe County School District serves 7 communities and about 4,000 students.
Over several months of 1992 to 1993, 5th grader LaShonda Davis was repeatedly assaulted by a fellow male student. The young girl was fondled, touched, and received sexual comments from the other student. Although she reported the incidents, teachers and school officials never responded nor took action.
A plaintiff is a person who brings a case against another in the court of law. Ariel Davis sued the Monroe County Board of Education on behalf of LaShonda Davis, her 5th grade daughter.
A defendant is a person or group being sued. The defendants of this case are the Monroe County School Board, the Superintendent Charles Dumas, and the Principal Bill Query. Davis's teachers, Maples, Pittman, and Fort, were among the members to receive reports, but Fort is the only one to not face direct charges because he had reported the incident to the principal.
Liability of the school. School district's liability when a school is responsible for your child's injuries. Lower courts had asserted the school boards could not be liable for student-on-student sexual harassment. Other courts held that school boards can be liable for students harassing other students. The Supreme Court came to the decision that school boards are liable when officials are deliberately indifferent to sexual harassment when they have actual knowledge and the harassment is severe, pervasive, and objectively offensive that it could deprive a student from extracurricular activities and educational programs provided by the school.
This case falls under the Title IX 1972 clause, which states, no person in the United States shall on the basis of sex be excluded from participation in, denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance.
The lawsuit. Ariel Davis sued the Monroe County School Board because her daughter LaShonda was being sexually harassed verbally and physically by another student at that school. Davis claimed that the school's compliancy created an unsafe environment that deprived LaShonda of educational benefits promised under Title IX of the Education Amendments of 1972.
Federal District Court. The lawsuit was first brought to the Federal District Court of Georgia. The defendants requested a dismissal of the case under the Federal Rule of Civil Procedure 12b-6, failure to state a claim upon which relief could be granted. The district judge agreed and motioned this dismissal.
The 11th Circuit of Court Appeals. Established by Congress in 1981, the United States Court of Appeals for the 11th Judicial Circuit has jurisdiction over federal cases originating in the states of Alabama, Florida, and Georgia. The circuit has 9 district courts. All states are divided into northern, middle, and southern districts.
Supreme Court. After the second dismissal, the plaintiffs again appealed the ruling from the Court of Appeals. Upon review, the U.S. Supreme Court decided to take on this case. The court ruled in favor of the plaintiffs with a 4-5 ruling. Justice Sandra Day O'Connor had the strongest voice in this decision.
Justice Sandra Day O'Connor was the first woman assigned to the U.S. Supreme Court. She was a Republican, but considered a moderate conservative. She served from 1981 to 2006. She has been awarded the nation's highest civilian honor, the Presidential Medal of Freedom, along with portraits, sculptures, and her bench chair. Justice Sandra Day O'Connor wrote the majority of the opinion of the court for the Davis-Monroe case.
The Supreme Court's decision declared that sexual harassment caused serious enough damage to have a systemic effect of denying the victim equal access to an education program, which violates the 1972 clause of Title IX. This violation held the school board responsible for not taking action.
The significance of this case. The Supreme Court came to the conclusion for Circuit 11 that indicates school districts will be held liable under federal law, Title IX, and only if they were deliberately indifferent.
Recent cases. A female junior at Glenwood Springs, Colorado, was raped by a fellow classmate. The case was reported, yet the school stated they only heard her version of the story and failed to perform any investigation. The following school year, the victim received harassment from the defendant's friends, and once again, her complaints were ignored.
School response. Prior to the police investigation of the incident, school officials ignored any claims of harassment. Other school officials reported behavior and emotional changes of the victim to her parents, yet the school continued to ignore the claims.
The victim continued to receive harassment and eventually transferred to a new school. After graduation, she avoided going to her dream college in the state because she feared she would receive harassment from classmates from high school. Her family's trial against the school is still pending.
Schools and sexual assault today. In the 2015-2016 school year, nearly 10,000 students reported sexual assault from fellow students across the United States. Yet, the response of these claims are often insensitive. Schools do not know how to properly handle these cases, and some simply do not want to handle the cases.
To prevent and resolve sexual harassment claims, Title IX has new procedures. Schools must have a publicly displayed policy against sex discrimination. They must also have a Title IX coordinator, and schools must have known procedures of how to file a sexual assault claim for students and steps to address the claim for teachers and other school officials.
It took 7 years and 3 trials for a 5th grade student to get justice after being sexually assaulted. The case that reached the United States Supreme Court has provoked policy changes to help future victims receive prompt responses and actions to their claims. And then you can find our resources on our Padlet. And thank you.
Thank you.